We've all heard those horror stories about disputes with the homeowners association, right? But it's not every day you get a front row seat to the actual legal hearing. Well, today, we're diving into a case where a pretty simple disagreement over a meeting notice just snowballed into a formal petition, sworn testimony, and finally, a judge's ruling. So let's unpack how this all went down.
Right out of the gate, this is the opening shot from the homeowner, Felicia Woodward. With just one sentence, she laid it all on the line. See, she wasn't just a little annoyed. She was there to legally prove that her HOA had dropped the ball on its duties.
So what was this all about? I mean, this wasn't some fight over loud parties or lawn maintenance. Nope. This came down to something way more basic: how the community was being told about upcoming meetings.
According to Ms. Woodward, the HOA had a system, a very clear, three-part system for telling everyone about meetings. This was, in her words, the customary and usual way. You'd get a big email blast, you'd see it on the official online calendar, and you'd see physical signs, sandwich boards, at all 7 entrances. This is just what residents had come to expect.
And here's the kicker. For this specific meeting on March 14th, she claimed the HOA did, well, none of that. No email, no calendar post, no sandwich boards. So from her point of view, this meeting was basically held in secret.
But here's where things get complicated. Because what a resident expects and what the law actually requires, well, those can be two totally different things. This case wasn't going to be decided on habit or custom. It was all going to come down to the cold, hard text of the law.
So the Arizona law is pretty specific. It says notice has to be given at least 48 hours in advance. It's got to have the date, time, and place. But the method? It's pretty flexible. A newsletter, a posting, or, and this is important, any other reasonable means. But the absolute crucial part here is that last line. Just because one member doesn't get the notice, that doesn't automatically cancel the whole meeting. And believe me, that single line turned out to be a really big deal.
So you've got customary practice on one side and the legal statute on the other. The hearing moves on to the evidence, and this is where it gets really, really interesting, because both sides came armed with digital proof that completely contradicted each other.
It pretty much became a classic he said, she said situation. But instead of words, they were using screenshots as their weapons. So let's take a look at the key piece of evidence that was in dispute: the online community calendar.
Okay, now check this out, because this slide basically shows two different realities. On the left, you've got Mrs. Woodward's proof, a screenshot she took on March 13th, the day before the meeting. It only shows trash pickup for the 14th. But on the right, you have the HOA's evidence, a screenshot taken 3 months later in June, which clearly shows the workshop listed for that exact same day. One calendar, two completely different stories.
I mean, the difference was so big that the HOA's lawyer didn't just disagree with her, he flat out accused her of perjury, basically of lying under oath. This definitely raised the stakes in the room.
But the HOA came prepared. They had their own digital ace in the hole, and it was pretty convincing. This report from their email service showed a crystal clear trail. On March 7th, a whole week before the event, an email was sent to Felicia Woodward. About 2 hours later, she opened it, and then she clicked a link inside. The HOA argued this wasn't just notice, it was proof she got it and even engaged with it.
All right, so you've got conflicting screenshots, an accusation of perjury, and a digital paper trail. How does a judge even begin to sort all this out? Well, let's get to the final binding decision.
After looking at all the evidence and listening to everybody's testimony, the administrative law judge came back with a very simple, very definitive ruling. Petition denied. Ms. Woodward lost her case.
The outcome is clear as day, but the why is what really matters here. Why did the judge side with the HOA, especially with that conflicting calendar evidence?
So the judge's logic boiled down to two key things. First, and this is a perfect example of why legal definitions matter so much, he decided the event was technically a workshop, not a formal board meeting. Because of that, the strict notice rules in the law didn't even apply. And then he said even if they did apply, that email they sent on March 7th, the one she provably opened and clicked, was legally good enough notice.
And beyond just losing the case, there was a financial sting. That $500 filing fee Ms. Woodward paid to bring the case in the first place? Yeah, she wasn't getting that back. The judge ruled the HOA didn't have to reimburse her, making this a pretty costly effort.
You know, this whole case leaves us with a really fascinating question.
Miss Woodward built her entire argument on what everyone understood to be the routine, the customary way. But at the end of the day, the HOA won because they stuck to the bare minimum required by the law. It's just a powerful reminder that in a formal dispute, what you've come to expect can often take a back seat to what's actually written down in the rulebook.